I thought I would start out just with a quick overview of the history and the background of these agencies. I know a lot of you are familiar with these ideas already, but since it is important to know where we're coming from when we talk about the administrative state, what we mean by that term and where the administrative state originated. There really are three stages in the development of the modern regulatory agency that we're all familiar with, things like OSHA and the EPA and these other agencies at the state and federal level. There's three stages, but about 1900 or so, there was a movement called the Progressive Age that was an intellectual movement that saw some, what they thought of as really revolutionary changes to the way government worked. Before then, the American constitutional system had been based on principles of classical liberalism, that is, that everybody should be free to pursue happiness in the way that they saw fit, with the government acting as an umpire to protect individual rights, but basically letting people run their own lives. But around 1900, that changed, and a new wave of thinking entered, which was really pioneered by people like Woodrow Wilson. And they held that government instead exists to shape and change and mold society in the scientifically correct way. That is, that government would be run by experts who would shape and mold society to meet the needs of history, which were somehow objectively determined and superior to the mere needs and desires of individuals. And they were the ones who really transformed what had formerly just been, government agencies that were charged with enforcing the law into what we think of as the first regulatory agencies. Then in the 1930s came the New Deal, and then again in the 1960s, the Great Society. And those two things really ramped up the size and scope of these agencies and ensured that they became kind of a fourth branch of government. Not actually, because of course the Constitution doesn't refer to these things at all, but they became so ingrained in our government that today, most of the laws under which we live our lives are not actually statutes that have been voted on by Congress or our state legislatures, but are instead rules and regulations that have been adopted by regulatory agencies that are staffed by people who are not elected and really only vaguely responsible to the elected officials. And that was considered a feature, not a bug, of the administrative agency when it was first created. It was created to be insulated against the democratic process, to be protected against voters. These agencies are supposed to be made up of expert bureaucrats, and for them to be answerable to voters was viewed as a bad thing, because then the voters might be prejudiced or ignorant and not know what was good for them, and they might interfere with the workings of the scientifically minded, rational apparatus of the state. So what we're talking about when we talk about the administrative state are the many different ways that these huge regulatory agencies at the state and federal level have sort of filled in what were supposed to be wide ranges of freedom with instead piles and piles of paperwork, regulations, restrictions. And that has had, the consequence that that's had for our constitutional system of government, there's really three big ones. The first one is it has really shifted the system away from one that presumed people were free unless the government had some good reason to stop them from doing what it was they were doing, into what I have called in one of my books the permission society. That is a society where you are not free unless you get permission from some government agency to do whatever thing it is that you wish to do. And we see over the course of the 20th century more and more of our lives being turned into this realm where we have to get government permission first. The second big thing that the administrative state means is really a shift away from the separation of powers. The principle of separation of powers written into our Constitution, it dates back to the mid-18th century, when the philosophers that our founding fathers read said that we needed to separate the idea of a court from the idea of a king, from the idea from a parliament, separate these three things from one another in order to ensure that they checked and balanced each other. because if they didn't, if they were all coalesced into a single group or single individual, then it would have too much power and be able to exercise its authority over us to our cost. So the Constitution and the state constitutions separate the powers accordingly, but the administrative state combines those powers. Regulatory agencies write rules, they investigate the possible infraction of rules, then they prosecute those in their own courts, not real courts, but what's analogous to courts, which is these administrative agency hearings. So it violates the separation of powers. And then, as I've already mentioned, the third big thing is that the regulatory state is deeply undemocratic in many ways. It was purposely designed to be that way. In extreme cases, it's designed so that even the bureaucrats can't even really be effectively controlled by elected officials. One that immediately comes to mind, probably one of the most extreme examples, is the California Coastal Commission, which is the regulatory agency that has authority over 800 miles of California coastline and is answerable basically to no elected official. I mean, in theory, the Coastal Commission members are appointed by elected officials, but it's designed in such a way as to prevent a majority from being replaced by any governor at any one time in such a way as to really be a check or a balance. So that makes the commission very autonomous. And in fact, the position of executive director of the California Coastal Commission, which is an extremely powerful position, was occupied by a single person, Peter Douglas, who basically wrote the Coastal Act all the way up until his death. Which was just a few years ago. So what you see is these regulatory agencies are insulated from voters. They are separated out from the separation of powers principle that was supposed to protect our freedoms, and it transitions our society into one where you are not presumed to be free unless the government gives you some kind of permission and authorizes you. And of course, if you have to ask permission from the government for something, then that means the government has the authority to determine the conditions on which you will be given that permission. And so it puts the government on a higher plane than the citizen. If you have to ask permission from somebody, you say, please, sir, right? Mother, may I? And the permission society that the administrative state creates, what it does is it puts the citizen at a point beneath the ruler, as opposed to being on an equal playing field, which is what our democratic system is supposed to be. And our a schoolhouse rock vision of the Constitution is that we vote for the congressman, he goes to Congress, he comes back, but he's still a fellow citizen. He's on an equal level with us. But the regulatory state doesn't do that. It creates a group of hired bureaucrats, often members of government unions, so they can't even be fired, who stand at a position above the citizen. And that has really deleterious social and cultural consequences in addition to the economic and political consequences that I've been talking about. So our paper that we're here to talk about today is an attempt to outline some ways to push back against the power of the administrative state. And I'm going to turn over to John now to get into more of the specifics on what we're talking about in our paper when it comes to trying to rein in these regulatory agencies and make them more accountable to the people that they're supposed to be working for.
Thanks, Dan. Really appreciate that. It was a great overview. And thanks to Anissa for hosting, and of course to all the callers for joining us. My name is John Riches. I'm the Director of National Litigation here at the Goldwater Institute. And I think at first blush, when we talk about the administrative state and administrative power, it might sound a little esoteric, but I think maybe there is not a more important topic when it comes to the preservation of individual liberty and the promotion of constitutionally limited government. So, and that's why I think the sketch that Tim outlined is so important. What we want to do is identify essentially some basic concrete proposals that we have developed here at the Goldwater Institute and that we have seen enacted as a way to practically push back against the administrative state. And the first of those is what I view as perhaps maybe one of the most offensive to due process and separation of powers issues, which is deference to the decisions of administrative agencies by the courts. And the way I like to think about it is if somebody described this system to me and they said, hey, here's a system that exists in some other country that I just visited, what would my reaction be? And if they were to say something as follows, this country has departments or agencies within the executive branch, and those agencies make rules that have the force of law. Those rules can deny you a license or a permit on which you base your livelihood. There can be criminal sanctions involved with these. There really are a whole separate body of law. Now, those rules were not put into place by elected lawmakers. They were made by unelected bureaucrats within the executive branch. Now, if you were alleged to have violated those rules, that same agency that made the rules would then hire an investigator to investigate the alleged violation. If that alleged violation went to court and was to be adjudicated, that same agency would hire an administrative law judge to conduct the adjudication. And in many states within this country, if the regulated party got a favorable result from an administrative law judge, agency heads in their sole discretion could set aside or overturn or modify the decision of the administrative law judge in the agency head's sole discretion. Now, fortunately, in this imaginary country, there's an independent judiciary. So you can take an action from an administrative agency and appeal it to a real court. But when you get to that court, because of things such as deference doctrines to both factual and legal questions, courts are obligated to put a thumb on the scale for the administrative agency. So what that means is that if administrative agency X or EPA says that you violated statute A, and you said, nope, I think statute A means B, a court is obligated to defer to the administrative agency's interpretation of questions of law, as well as fact. I think if we were to describe that system to most people, they would say that really due process and substantive separation of powers doesn't exist in any meaningful way. Well, that is the current state of affairs in the United States at the federal level, and for the most part, that is the state of affairs in administrative law at the state level in the vast majority of states. We live in a system in the administrative law context where unelected regulators at administrative agencies are lawmaker, sheriff, judge, and jury. And if those decisions are challenged in court, our independent judiciary is obligated to defer to an administrative agency's findings. This has largely been the result of a variety of judicial precedents, both federal and state, starting in large measure with a Chevron decision from 1984, which says that if there's ambiguous statutes, then the courts put the thumb on the scale for the agency. Also, the Auer decision, which was dialed back recently in the Kaiser decision, but basically said that an agency gets a thumb on the scale when it interprets its own rules. But the short story is, this is a problem, of course, in terms of our separation of powers. There's a serious systemic problem when you have one branch of government making the law, investigating it, and adjudicating it, and then having the judiciary defer to it. But it also creates a practical accountability problem. And the problem is this: regulators know that they can create expansive rules. They know they can investigate borderline violations of those rules, and they know they can adjudicate close cases in their favor. And they know that if they're challenged, they're probably going to win. So what's the natural result? It's more and more arbitrary rulemaking. It's more investigations. It's more finding of violations. It's bigger and more invasive government. It results in things like the federal EPA calling a puddle in your backyard a water of the United States. That's subject to federal jurisdiction. That's an exaggeration, but only slightly. Or a state licensing board claiming that somebody who braids hair must conduct 18 hours of training at cosmetology school, even though 0 of those hours have to do with hair braiding in order for them to practice their trade. So it creates this enormous accountability problem where regulators simply are not incentivized to make rational, modest, prudent decisions. Now, on the other hand, when there is accountability, the result is more sensible rulemaking and more sensible enforcement actions. So what we did at the Goldwater Institute is we looked at this problem and we looked at its origins and decided how can we best approach this from a state-based reform perspective. Now, it turns out that most states base their administrative procedures code, the laws that govern how these administrative agencies operate and how you appeal their decisions, et cetera, the states base their codes on the federal version. So about 36 states base their codes on the federal analog. And of course, the courts that have allowed for this type of deference have done that when they've interpreted this Administrative Procedures Act. So what we did is we went in and we created model legislation that dropped a very simple sentence into State Administrative Procedures Act, which says as follows: in a proceeding brought by or against a regulated party, the court shall decide all questions of law, including the interpretation of a constitutional or statutory provision or a rule adopted by an agency, without deference to any previous determination that may have been made on the question by the agency. That is now law in Arizona. It has been considered by a number of other states, and it can be easily implemented in states throughout the country that have similar administrative procedures codes as the federal government does. So why do this? Why start with the states? This is a very important reform in its own right, because administrative law system exists broadly at the state level. And of course, it can also be a model for federal reform. As more states enact these measures, then the federal government can take them up. Look, administrative deference is offensive to both due process and separation of powers. It results in agencies that are not accountable to elected leaders. They're certainly not accountable to the parties that they're regulating. And this simple statutory reform will inject accountability into a system where it's absent and help restore some of these separation of powers and due process issues that we had highlighted. And before I go any further with our next topic, Tim, do you have anything you wanted to add to agency deference?
You know, you in your comments, you said, imagine that you were trying to explain this to somebody in the form of another country, right? You said, imagine there was a country where this was. It reminded me of the case called Sackett versus EPA from, I think it was about 5 years ago now, maybe a little longer than that. And in that case, there were property owners in Idaho who laid out some gravel and began to build a foundation for a house that they owned on some dry land, and the EPA showed up and sent them an order literally declaring their dry land to be a wetland, just like you said, and fining them $75,000 per day unless they agreed to remove the improvements that they had made. And then this order listed a long list of things they were required to do. They were required to plant certain kinds of plants in certain locations on their land. They were required to allow government officials onto their property at any time to inspect and make sure that they were following these rules. And they would be fined $75,000 per day if that happened. And they said, well, we would like at least to have a hearing to try and prove that our land is not a wetland. And the EPA said, you're not entitled to a hearing under the law. That case went up to the US Supreme Court. And sure enough, during the oral argument in the Supreme Court, Justice Alito said just what you said. He said, I can't believe that this is happening in the United States of America, that a person can be deprived so extremely of their property rights, of their right to due process, without even having a hearing. And that really, honestly, if you're familiar with these kinds of cases, you know, that is pretty routine, that kind of behavior by administrative agencies. As Ronald Reagan used to say, the first role of the administrative agency is to defend the administrative agency. That's the #1 priority.
100%. And of course, it's maybe it's a little more esoteric until it happens to you or happens to the Sacketts, and then you're thrust into this system with very little protection. I'd like to switch gears a little bit to discuss another reform, although it's a little bit related on the accountability piece. And this is an area that we've done a lot of work on involving occupational licensing. Now, as I'm sure a lot of the callers are aware, an occupational license is a government permission slip to work. Many of the callers likely have one. In the 1950s, about 5% of professions required a government permission slip before you could practice a particular trade. Most of those were in the healthcare industry. Today, depending on what state you're in, about 1/4 to 1/3 of all jobs require an occupational license. It's pretty extraordinary. That means that in almost 1/3 of all cases, you have to go to the government, satisfy the government's arbitrary criteria before you can work in what you feel is the job that of your choice. And it doesn't just apply to doctors and lawyers and other professions that may arguably have a public health and safety nexus. It applies to barbers and cosmetologists and locksmiths, chimney sweepers in Vermont, bed salespeople in West Virginia. The great state of Louisiana licenses florists. In order to sell flowers in Louisiana, you have to get a license from the state. You have to take both a written exam and a subjective exam, which is graded by already licensed florists. So you think they have an incentive maybe to keep new entrants out of the market, just to sell flowers in the state of Louisiana. So, I mean, look, far too many things are licensed. That's a major problem, a separate problem almost in its own right. But this whole licensing regulatory regime faces the same exact issue of accountability that exists in the context of deference that I was just talking about. And the reason for that is because of different legal standards of review. So, for example, if the government were to infringe on your free expression rights, your First Amendment right to free speech, they were to say, you can't go and organize a protest on this date or time or whatever, and you were to challenge that decision in court, the courts would review that government restriction under what's called strict scrutiny, which is the highest standard of legal review in the constitutional context. And what that means is that the judge would turn to the government lawyer and say, you better have a really, really good reason for restricting this right. And whatever restriction you used better be narrowly tailored to advance that really important reason. Well, if the government restricts your ability to get a job, to get an occupational license, or to work in the job of your choice, the exact opposite is true. Courts examine that under what's called rational basis, which essentially means the government's going to rubber stamp all but the most arbitrary government action, and in many cases, courts are going to rubber stamp the arbitrary stuff too. I'll give you a quick example of a case we litigated here at the Goldwater Institute involving a woman named Lauren Boyce. Lauren contracted cancer, and while she was undergoing chemo treatment, she couldn't leave her house. She couldn't leave her house to do much of anything, but one thing she couldn't leave for was cosmetology services, to get her hair cut or her makeup done. Fortunately, Lauren survived, and like all good entrepreneurs, she looked back at her experience and saw that there was a demand in the market. So she started a small business called Angels on Earth. And her business was to just dispatch licensed cosmetologists to the homes of people who couldn't leave, either because they were too ill or they were otherwise homebound. So that's all she did. The people already held the license, she would just dispatch them to the home. In stepped the Arizona Board of Cosmetology, and they told Lauren that the act of dispatching licensed cosmetologists turned her into a salon, and she now needed a salon license, to which she reasonably replied, I don't operate a salon. I also don't happen to cut anybody's hair or do anybody's makeup. All I'm doing is sending licensed cosmetology to homes. The board persisted. The Goldwater Institute got involved, and we represented her, and we won an early litigation victory, and the board eventually backed down. But had that case gone the distance, had it been decided on the merits, because of rational basis review, there is a very high probability Lauren would have lost her case. That's how deferential the legal standard is under existing law. That a regulation as irrational as telling somebody that doesn't operate a salon that they need a salon license might be upheld, I think demonstrates why this system is stacked against the person that just wants to earn a living. Now, of course, not everybody can get a free lawyer. Not everybody's gonna have the time or the energy to litigate these things. And of course, for every Lauren Boyce, there's hundreds of people that are being subjected to this regulatory regime without the benefit of attorneys and with a legal system that's still stacked against them. So when we looked at that case and we looked back over it, we said, hey, look, we're gonna keep doing these cases, these occupational licensing cases, but why do we keep banging our head against the wall trying to get incremental reform in close cases when the legislature might be able to provide a broader, more holistic solution? So we developed what's called the Right to Earn a Living Act, which does a very simple thing. It directs courts that in the context of occupational licensing, if the government's going to impose a restriction on your ability to get a job, the government has to do it for a health, safety, or welfare purpose. Can't be to protect an existing industry or something like that. And whatever restriction is used better advance that purpose. So telling a salon, a person who doesn't operate a salon that they need a salon license isn't going to fly. Now, of course, at the time we were advocating for the passage of this reform, you had the naysayers. You said, well, this is going to result in a flood of litigation, et cetera, to which we responded, no, this is not going to result in more litigation. This is going to result in less regulation, smarter regulation. The Right to Earn a Living Act was adopted by the Arizona legislature and signed into law 2 years ago. It has been considered and adopted in a different form in Tennessee and many other states. And our experience here in Arizona has been exactly that. Not more litigation, but smarter regulation. One of the very first cases we were involved in involved a woman named Annette Stanley, and she was a licensed behavioral health counselor and had been for many years. And in order to become a behavioral health counselor, she needed 2,000 hours of supervised work. So where her supervisor was observing her perform her job. And when she was licensed out in Kansas, she satisfied all these hours, but she did it in an independent clinical setting. So she was supervised by a PhD, somebody who'd been in this practice for over 20 years, and the two of them operated their own business. That's all perfectly legitimate in Kansas. When Annette's husband got a job in Arizona and they had to move the family out here, she sought to transfer her license. The Arizona Board of Behavioral Health said, no, we have a rule, which the Arizona Board put in place itself, not the legislature, that says if you have an ownership interest in a firm in which you've received supervision, we don't count any of those hours. You got to go do 2,000 more hours before we're going to license you. So fortunately, Right to Living Act was law. We sent them a letter, and rather than face the inside of a courtroom, rather than be held accountable under a fair standard of review, the board, in the quickest manner I've ever seen this done, changed its rule, eliminated the ownership requirement, and in fact broadened out some permissions for people from out of state receiving in-state licenses. So this law did precisely what it was designed to do, which is create accountability so that the regulators would make better decisions without having to be brought to court to do it. And with that, Tim is going to address, I think, another very related issue involving the permitting process and how that ought to look.
You know, one of the things that I think we, especially as lawyers, are very familiar with when it comes to these agencies is that sometimes, in fact, most often, the abuses that these agencies engage in are not done out of any kind of bad motives or nefarious desires on the part of the regulators. Quite the opposite. It's often because they're trying to be diligent that they go too far. And the reason why is because they see it as their job to, for instance, protect the environment or whatever it might be. And so naturally, they interpret their statutory authority as broadly as they possibly can. And they exploit vague rules to empower themselves to do what they think is right, but which actually ends up hurting people. And so vagueness is very often the number one problem when it comes to these regulations and the power that these regulatory agencies have. I often explain how regulatory agencies work this way. I say, imagine you're running for Congress on the no bad things platform. You're against bad things. Well, of course, everybody's going to vote for you because they're against bad things too. As soon as you get elected to Congress, you pass a law that says, number one, there shall be no more bad things. Number two, there shall now be the No Bad Things Agency, which shall have the power to decide what a bad thing is, investigate potential bad things, and punish bad things when they see them. And then you get to go home and say, look, I outlawed all the bad things. I'm a good guy. I move on to the next issue. Meanwhile, the bureaucrats all get to work. And that's where the real problem is, the devil's in the details and so forth. So one of the things we really want to do in trying to get the administrative agencies to focus on the things they should be doing and not focus on the things they should not be doing is to reduce this vagueness. And the Supreme Court of the United States has given us 3 procedural standards for how to accomplish that. And in a series of decisions back in the 1950s, the Supreme Court said whenever the government requires you to get a license for some activity that you have a constitutional right to do, I mean, of course, they can outlaw activities that you have no constitutional right to do in the first place. But if they're going to require you to get a permit to do something that you have a right to do, then the criteria for getting the license have to be clear. It can't be just vague. It can't be just like, if we feel like it, we'll give you a license. Second, there has to be a clear deadline of when they're going to give you an answer when you apply for a license. It can't just be, we'll give you a license when we get around to it. And third, there has to be an opportunity for you to go to court to challenge the government if it wrongly denied you the permit or the license to begin with. Those are very simple procedural guarantees. They really shouldn't be a problem for anybody. But unfortunately, state and local governments and the federal government very often ignore these rules and write licensing and permit requirements in very vague terms, don't give you a specific deadline when you'll get an answer. And then if you want to challenge the government for wrongly denying you the permit, you have to go through an administrative agency hearing instead of going to a real court. And the problem with administrative agency hearings is the rules of procedure and the rules of evidence that apply in the courtroom don't apply there. So, for example, many states allow administrative agency hearings to use hearsay evidence, which would be disallowed in a courtroom. And then once you lose there, and you're always going to lose in the administrative agency hearing because it's the same agency that denied you the permit to begin with, so of course they're going to affirm that, right? They're going to say they did the right thing. They're basically the prosecutor paying the judge, right? So when you then appeal that decision after you've lost to a real courtroom, a lot of states say that you can't introduce any new evidence. So as a result, what happens is you lost your case in the agency based on hearsay that they shouldn't be allowed to use. And then when you appeal that, you're not allowed to challenge the hearsay. Instead, the judge has to rely on the hearsay that was used by the agency to begin with. So these procedural protections are very often disregarded at the state and local level. So one of the proposals that we have in our paper, we've got several, but one of the ones we want to highlight is what we call permit freedom, which has three simple requirements: clear standards, a specific deadline, and an opportunity to challenge the government if it wrongly denies you the permit. Just to give a couple examples of how these apply in real life, the government often imposes vague standards for getting a permit, things like good cause, or one that particularly annoys me is building permits that say that you can only build a house or whatever if it looks nice, in the opinion of the regulatory agency, right? If your building fits with the character of the neighborhood. What does that mean? It means whatever the government says that it means, right? Or gun permits that say you can have a gun if you for good cause, right? What's good cause? It's whatever the government says it is. Those kinds of things clearly violate the rules that the Supreme Court has already said that permits have to follow. The other one is the deadlines. Government should be required to give you an answer on a permit application within 30 days, 60 days, 90 days, whatever the number might be. The number doesn't matter so much as that there's a specific date when you get an answer. The reason is because courts have said you're not allowed to sue one of these regulatory agencies until it gives you a final answer. So agencies will often drag their feet and take as long as they can before making a final answer because they want to avoid going to court. So having a rule in place that says they have to give you an answer within 30 days. Some states have a rule that says if they don't within 30 days, then your permit is automatically granted. That's a great idea. Things along those lines are very important. And then again, an opportunity to challenge a wrongful permit denial in a real court where you can get real due process and have a chance to make your case in front of an independent judge who doesn't work for the same agency that denied you the permit to begin with.
In the last few minutes that we have, I'll chat about our last reform, and you'll kind of see how a lot of these are related, particularly permit freedom to deference is particularly related. But this one is really just a good housekeeping measure. So we mentioned earlier that these administrative agencies get to make the rules on their own. These unelected bureaucrats get to just decide and make the rule. And those rules are codified in administrative codes. That's the body of rules that are made across the state government. Now, of course, these administrative codes always grow. They never shrink. Arizona's administrative code, for example, has 5.6 million words. Researchers at the Mercatus Center estimated that includes some 64,000 separate restrictions on our daily lives. And Arizona's is frankly on the smaller side. And these include all sorts of things, all sorts of, a couple examples in Arizona's codes. Apparently you can't sell water guns at the state fair. That is codified in the administrative code. You can't have alcohol delivered anywhere except for the address it says on the state license. So if a restaurant or a bar is flooded or had a fire, I guess you're out of luck with those deliveries. But of course, it's important for any of us, for individuals, for businesses, and certainly for the government, who's imposing hundreds of thousands of restrictions on our daily lives, to examine every once in a while what is working, what is not, to keep the things that are working and to eliminate those that aren't. So this is the first piece of our regulatory reset model. It requires a one-time sunset of the existing administrative code to make those sorts of determinations. Now, a separate issue, as we've already alluded to with administrative codes, is that they're put in place by unelected bureaucrats. who are not part of the legislative branch, who are part of the executive. Yet, of course, these rules have the force of law. The second component is that the legislature must review and reauthorize the code on an annual basis. So you have the one-time sunset that allows the rules to be sunsetted, and those that are working can be brought back. Those that aren't won't. And then you have the annual reauthorization by the legislature, so that our elected lawmakers will have some oversight over unelected bureaucrats at executive agencies. This idea, this regulatory reset idea, was predicated on experiences from 2 other states. So Rhode Island, for example, allowed their entire administrative code to expire when they moved from paper to an online version. And what we saw in Rhode Island was that 31% of that state's regulations were eliminated when they had a one-time sunset. And that's Rhode Island. Idaho had a very similar experience with this. They had a law that said the legislature had to reauthorize the administrative code. Last year, the legislature decided not to reauthorize the administrative code, so the entire code sunsetted, and the executive, the governor, and in conjunction with the legislature, were able to determine which of these worked, which of these didn't, and greatly reduce the regulatory burden in that state. So, I mean, look, I think it's just pretty common sense that we all got to clean our house. We all got to clean out our policies from time to time. We should expect government to do the same thing. And this type of reform will also help to restore some of the separation of powers issues that exist when you have one branch of government, the executive, making laws that govern all of us in many, many ways in our daily lives. So that's the overview of our proposals in the paper, and we're happy to open it up to any questions.
Yeah, this is Gary DeBerge calling, and I am the district captain for the Convention of States here in Arizona LD12. You were just talking about cleaning house in the administrative state. Sounds like at the state level. Are you all familiar with the Convention of States project?
Yes, we are.
Okay. As you know, then, there is a mechanism in the Constitution called Article 5, where we, the people, have an opportunity to bypass Congress and amend the Constitution. I just wonder if the Goldwater Institute would support the current resolutions that are circulating through the states to have 34 states send a resolution to Congress to hold a Convention of States whereby we can look at 3 potential amendments. They are term limits. They are, the second one is a balanced budget amendment, and the third is to restrict the scope and power of the federal government. Now, none of those 3 items are specified as to when or what or how. It's up to the convention to do that. Right now, we have 14 states that have sent the resolution. Looks like 2 more, possibly 3 more, but they're now quarantined with the coronavirus, so it looks like it'll be a while yet. So we might be halfway there by the time summer is over. I just would like your thoughts on that.
Thanks, Gary. Appreciate the question. And yeah, it's obviously an important issue. Of course, because there's groups like yours that are focused exclusively on it, it's not an issue we have worked on in any great detail. Of course, limitations on the size and scope of the federal government is certainly something we support, but probably not in a position to comment on those specific reforms at this moment.
You know, and although we aren't necessarily opposed to changing the federal constitution if events warrant or something, our focus has been to try to emphasize the importance of state level reform. You know, when we talk about the administrative state or regulatory agencies, people just naturally, they think of things like the EPA and things like that. But it's important not to overlook how powerful and pervasive state regulatory agencies are. And I do worry that has not been emphasized nearly enough. You know, we were talking earlier about the Sackett case and the Clean Water Act case that I mentioned earlier. Well, you know, we do state regulatory cases very frequently. As some years ago, I worked on a case in California where my client sold a kind of garden fertilizer that was made of worm castings. That is worm poop. And it's a part of normal soil as it is, because worms live in ordinary soil. But if your soil doesn't have enough in that, then your plants aren't going to flourish. So my client sold worm castings at nurseries that you could then put in your flower beds and make your plants stronger. Unfortunately, he made the mistake of putting in his advertisements that if you used his product, your plants would be strong enough to resist pests. And the California Department of Pesticide Regulation declared that therefore it was a pesticide and had to be approved through the state procedure for approving pesticide. Now we're talking about literally dirt was deemed to be a pesticide in the state of California, which, by the way, the California EPA very loudly on their website proclaimed the fact that they themselves used this same product in the flower beds at the California EPA headquarters in Sacramento. Nevertheless, they deemed it to be illegal, and we challenged this in an administrative agency hearing, and we pointed out that under the government's argument, water itself would be a pesticide because you could use water to spray aphids off of your roses. And sure enough, the California Department of Pesticide Regulation admitted that and said, yes, we would deem water to be a pesticide under that theory. So this is an indication of how extremely expansive. By the way, I lost that case. But that was before I came to work at Goldwater, so you can't blame Goldwater for that one. But that's an example of how extremely powerful state administrative agencies are and how important it is to focus our attention on protecting people against state governments as well as federal.
Hi, this is Charles Heller from Liberty Watch Radio in Tucson. Good afternoon.
How you doing, Charles?
Better for talking to you. Have you considered a statute or model legislation for a statute? Because I know you don't write laws, you write models. I get that. But have you considered a model for a law that would enable it would be an enabling act to the direct enforcement of Article 2, Section 2 of Arizona's Constitution, which for those of you who don't have a photographic memory says that all power is inherent. It's the stated purpose of government, that all power is inherent in the people, and the purpose of government is to enforce the rights of the individual citizen. Have you thought about some kind of statute that would A, refer back to that, or B, have you thought of a statute that might more quickly enable the use of 2016 Senate Bill 1487, which any municipality which doesn't comply with state law loses their state shared revenue?
Thanks, Charles. Yeah, it actually raises an important point. Of course, all state officials have taken an oath to uphold the Constitution of the state of Arizona, and there's provisions in there that are essential to the protection of individual liberty, including Article 2, Section 2. Interesting idea what a statutory regime would look like. I don't quite know what an enforcement mechanism would look like. But Charles also raises an important point about the expansive nature of government power at the local level. Oftentimes, these administrative agencies are not just at the state level. You have zoning boards and all sorts of municipal level layer of bureaucracies that either flout the Arizona Constitution or state statute. Even when the legislature's acted, oftentimes cities ignore it. And so to the extent there's mechanisms to hold local government actors accountable when they violate state law or our constitutional protections, I think that those should certainly be explored and expanded when necessary, including here in Arizona with our 1487 law.
And as on a broader level, it's unfortunately very true that state constitutions, not just Arizona's, but every state constitution, they contain a lot of provisions that often just get ignored. Provisions that a lot of state legislators don't even bother reading, unfortunately, and that really provide promises for protection that are not being enforced as they ought to be. The Constitution is a promise to the people the government will follow certain rules, and unfortunately that gets ignored. One of the ones that comes to mind that's not related to the project we're working on today, but still, is Arizona's Private Affairs Clause, which is Arizona's version of the Fourth Amendment that requires warrants for searches. The Arizona provision is a lot more protective than the federal constitutions, but unfortunately, it has been largely ignored by state courts and state legislatures ever since the Arizona Constitution was written. We're participating in some litigation right now that we hope will change that. But it's a good example of how, unfortunately, protections in our Constitution do get ignored and forgotten unless people are willing to stand up and see them enforced.
Which again raises an important point that Charles put his finger on and that Tim just mentioned. We often say here at the Goldwater Institute, we don't have one constitution, we have 51. And the federal constitution is just a floor to the protection of our rights. State constitutions can go above and beyond in expanding those rights. And that's why so much of our focus is on state constitutional litigation, on our litigation center, and on state-based reforms in developing model policies.
My name is Alan Wegley. I'm the Arizona State Director for Convention of States. Gary DeBurge made a comment just a little while ago. First of all, let me say that I applaud everything that you are doing. I think it's long overdue and in the right direction. Unfortunately, and this isn't a criticism, all of the reforms accept the notion that the administrative state will still live. And I believe that we must dismantle the administrative state. It is clearly unconstitutional, and that's why we believe in Article 5 convention that could propose an amendment to the Constitution to do just that is really a great way to go. But again, thank you for all that you're doing. It's great. And if there's any way in which we can help, we'd love to hear it. Thank you.
Thank you. Appreciate that comment. And of course, what we always try to do is look at the best, most effective ways to reduce the size and scope of the administrative state in ways that we can that are achievable, and hopefully that means that as these reforms are paired with one another, the power of the administrative state is greatly dissipated.
And John, I think we should emphasize, our proposal does include eliminating literally every regulation on the state's books if the state legislature isn't reenacted. I think that's, as you mentioned in your earlier comments, one of our proposals is that that regulations should be sunsetted and require legislatures to go back and reenact them and justify doing so. Make the argument, why is this regulation necessary? And if it's not necessary, then it should be eliminated entirely. And if that means every regulation that some agency is enforcing is eliminated, then the agency itself should be eliminated.
Hi, Ben LePack with the 1889 Institute in Oklahoma. Thanks for putting the call on, guys. You mentioned that with the right to earn law, some people were concerned that there would be a flood of litigation, that you haven't seen that. I was wondering if you could just talk a little bit more about that. I don't know if you've made an effort to try to put any kind of numbers to that, or just anecdotally how you've seen litigation reduced, but just kind of explain that a little bit more.
Thanks, Ben, and hope you're doing well out there. Yeah, we have basically what we've done, try to keep a track of all the cases that have been brought under this law in Arizona. So we have public records requests out to various agencies in that regard. And what we have not seen is an uptake in litigation. We've been involved in 2 cases involving the law since it was enacted. In both of them, the regulators changed their conduct before the case ever got to court. So, at some point, regulators won't fold. This will probably go up. These cases will probably be decided by the appellate courts, but we just haven't seen that yet. And as I mentioned earlier in my comments, that's really good. That's what the law was designed to do. It was designed to change behavior at the outset so that these things don't end up in court, so that we get better decisions from regulatory agencies where they're frankly embarrassed to take them to court, and if they know they're going to lose, they'll change their behavior before it ever gets there.
And the argument, the whole this is going to open the floodgates for litigation argument is so often a pretty desperate argument on the part of the government. First of all, when the government is going to deprive a person of his or her individual rights, the government owes that person both a moral and a constitutional duty of giving that person a real chance, a day in court, a hearing before an independent judge to make his or her case. And when a government agency says, no, we would prefer not to give somebody a hearing, not to give them an opportunity to challenge the restriction on their liberty because, why, my goodness, that would tie up our court system and so forth. Well, yeah, maybe we should have a system where people have the ability to fight back instead of just being run over by agencies that are overzealous in their prosecutorial practices. So I've never been very sympathetic to that argument, and the numbers just aren't there. I mean, what you find is that there are so many obstacles to people going to court to begin with that giving them the opportunity to do so rarely results in the kind of flood of litigation that bureaucrats like to scare little children with.
We are right at about our closing time, so we'll go ahead and wrap it up. We will wrap it maybe on a silver lining with this last point about the current coronavirus crisis. Of course, what we're seeing is unprecedented in terms of government agencies for the first time lifting some of the restrictions that we've been talking about, allowing healthcare providers to practice in states without satisfying all of the licensure and regulatory requirements, removing some onerous restrictions in terms of getting supplies to different locations. And when we look back, I think what we're going to find is that as we're down at legislatures advocating for these reforms and the Chicken Little crowd is out there saying, well, if you get rid of this regulation, the sky's going to fall, we'll have an opportunity to look back and say, well, we got rid of them here and the sky didn't fall. In fact, maybe government operated better in many ways under certain circumstances. So thank you all very, very much for joining us on the call, and we are available anytime to answer questions. Feel free to reach out, and you can get a copy of our paper at goldwaterinstitute.org and let us know if you want a paper copy, and we'll get some out to you.
Thanks, everybody.